innovation regarding corporate laws. Our esteemed speaker for today is Advocate Pooja Tiwari, ma'am. She is currently working as a research analyst with the global research team of a leading consulting firm. She has worked as a legal researcher with premier institutions, including National Law University, Delhi, Indian Institute of Corporate Affairs, and OP Jindal Global Law School. She has done LLM in corporate and commercial laws from the Wib National University of Judicial Sciences. So before we dive into this session, I request all the audience to hold on their questions and to have a question and answer session in the end. Without further delay, I would request you, ma'am, to start the webinar.
Hello, thank you so much, Vaibhavi, for the introduction. So, yes, we'll directly dive into the session today because I think, it's better that we divide the session in a form that we are able to also engage our audience. And considering also in my information that major students are part of the first or second LLB or first or second year students. So I've kept it as an introductory session. If this subject or the topic interests you, we may have some more in further. So the session will be 50-minute long and we'll have 10 minutes for Q&A. In between, if you have any question or query, you may please write your queries in the chat box so that we may take them after the session. So with this session, we can expect certain learning outcomes that may include that after this session, you may be able to understand what are the basic concepts of company law. You will be able to differentiate between a partnership and a company concepts. You will be able to decipher what are the legal aspects of the process of formation of a company. You will also be able to understand the concept that lies behind a separate legal entity or lifting up of a corporate veil. In this session, we'll start off by talking about, because see, no concept or no topic can be dwelled into before we go into the basics of it. So it's very important for us to start off our discussion on corporate law. We need to understand what is the concept of company itself. So in this session, we'll be dwelling into what is the meaning of company and the concept behind the law. We'll dwell into how over the span of period the law evolved. What are different types of company? What are the salient features that are important in order to constitute a company? And then we'll also dwell into, I try to put in two relevant doctrines because I believe that it's very important and pertinent when we talk about the salient features, that we also talk about these two specific doctrine, that is separate legal entity and lifting up of a corporate veil. So this will be the flow of our session. Now, jumping directly into the concept and the topic itself, company. So when we hear a word company, what exactly comes to your mind? Anybody who can, jump in and give an answer? Yes, Aditya, Ramanathanji, if you can just tell me what comes to your mind when you hear the word company. A company is a legal entity. Now, all that notions we'll get into, Rosie. If somebody can tell me, what do you understand company as a term itself? Incorporated under Company Act. Okay, it's an artificial person. Good, we are getting there. Anybody else? Okay. So
what is the regarding of this criminal case?
Sorry?
This meeting is starting criminal case or company law?
Sir, in this session, we'll be only talking about company law. What are the basics of company law?
Okay.
Yes, thank you. Group of person come together for profit. Very good. Exactly. So the meaning of company is derived from two Latin words that are com and panis. Com means together and panis stands for bread. So in a literal term, a company is an association of person who, in that time when the concept came into being, was considered that when certain set of people took their meal together, those association would be termed as company. In a later span of time, the word evolved and it circumscribed to the meaning of an incorporated association of a person. So here a person can be two type of person. We don't have to confuse ourselves as in that a person only would have a single meaning here. It would mean two type of people, which could either be person as in a natural person, somebody who's created by nature, like a human being, you and I. And secondarily, it is an artificial or a legal person, which gets its existence by virtue of law, just like a firm or a company. So a company may be incorporated as in having an association of person that could be either natural person or legal person. So now, after we've understood the concept of company, we'll dwell into its definition that is given under Section 2, Subclause 20 of the Companies Act 2013. It defines company as a means of association of person formed or registered either under the present Companies Law or under the Companies Act 2013. So any association of person that is registered under the act will get a identification as a company. So if we put it in a layman term and we simplify it, we learn that a company is a legal person or a legal entity that has some special features. Like here, we've understood the special feature being association of persons. There are more features attached to it, but we'll dwell into them later when we proceed with our session. So what it actually does is that it has all the legal rights, it has relation and conduct of a person, and thereafter what it does is it actually functions in order to gain some economic profits. So it can be considered as a body which has a legal entity, like we've been given an answer by one of the attendees. Now that we've understood what is company as a term and we've understood how it has been defined under the law, it becomes important to understand that after a company's association was there, how did the law come into play to rescue the company law, to standardize the functioning of a company. So basically, this concept actually took into play when an English Companies Act was introduced in the year 1844. Thereafter, in the year 1850, the company legislation was passed, which was then known as Joint Stock Companies Act. Later in the year 1857, it was replaced by another act, which introduced the concept of limited liability for the first time in the country. This act, again, as a Joint Stock Companies Act, was modified in the year 1860, wherein it also took banking companies under its purview. And thereafter, in the year 1866, there was a comprehensive act which provided incorporation, regulation, and winding up of companies. So you would see that over the span of time, there were laws that were introduced from 1850, but they were not directly addressing about the constitution of a company or about the processes of a company. It was in the year 1866 that the first comprehensive act was introduced. Thereafter, it again was recasted in the year 1882, and then it remained in force in 1913. In the year 1913, we've had our Indian Companies Act, which followed the English Companies Act. So as you know, the Britishers and the British laws had a high impact on our own laws. So the law, Indian Companies Act, was highly inspired by the English Companies Act. It was thereafter amended a few times. And finally, in the year 1956, the Companies Act was passed, which came into force in the year 1956 itself, which was also based on the English Companies Act 1943. It is though the current act is also, thereafter when the third later stage, when there was another amendment that was introduced to in the year 2013, it was to a great extent similar to the act that was introduced in the year 1956. And the act itself is very comprehensive. It inculcates around 658 sections and around 13 schedules. It was brought into, and then the current law that we have, it was introduced in the year 2013 on 29th August. So all of this history becomes relevant because we have to see that how the company and its functioning and the process always played a significant role in our country. Since the 1880s till 2000s, there have been so many amendments in order to make sure that with the changing paradigm, necessary amendments were made. It's very important that it's very important that we keep into account that how relevant Companies Act 1956 was, because even though earlier we saw very near amendments, I mean, within the years, there was closer proximity with, however, when we see a 1956 Act and current 2013 Act, there was a great time that went by. And the year when the current act was passed, it actually became very relevant and needed to have an amendment to the 1956 Act. So now that we've understood what is the concept of company, how does it hold relevance in our current act, and how over the span of year, statutory measures have been taken to evolve and to constitute company into a structured format. Now, the second thing that we ponder upon is what are the different types of company. Okay, now that we know that yes, we can have a company, it should have by the virtue of law, it gets a legal entity status. But now, what are the different types in which a company can be constituted? So the Companies Act 2013 itself provides for certain kinds of company that can be promoted and registered under the act. The three basic types are private companies, public companies, and one-person company. And thereafter, there are further segregation of how the company can be constituted and incorporated. A, by virtue of its registration, B, by virtue of its incorporation, and C, by virtue of its liabilities. So A, we have already discussed that there are different types on how you can register them. Now, basis of incorporation. As for the incorporation, there are again certain categories. A, statutory company, a company that is constituted by special act of parliament or state legislature. The provisions of 2000 Companies Act apply to certain companies, but not this category of the company, because it has a government role into it. Certain types of such companies, if I have to tell you, would be LIC, RBI. So because these are government entities, so they are considered as statutory companies. Now, second category is registered company. So we earlier what we read about what are the different categories of registration. Now, what that itself when you get it registered in a particular format, it becomes a registered company. It could be a private registered company, it could be a public registered company, or it could be one-person registered company. So you have incorporated a company which falls under the purview of Companies Act or in any other previous company law, any other here being 1956 Act. Now, the third category is classification on the basis of liabilities. A registered company may be again further be classified. We've seen, okay, first we registered it under three categories. Now, after we've registered, how are you planning the incorporation? So once you've planned an incorporation, you've registered it. Now, after the registration, there are certain level of liabilities that may fall upon. Okay, so this is a very significant category and classification, because to a great extent this may either put in liabilities on you, or you may get rescued. So this classification is very pertinent when we are constituting a company. So a registered company can be classified into three categories: A, company limited by shares; B, company limited by guarantee. By shares, it's easier to understand. A certain person has certain shares, certain person has some other. Let's say there is a company which has A, B, C partners. A has 30% of share, B has 30% of the share, and C has 40% of the share. Okay, so this become a company limited by shares. Then is company limited by guarantee. Here, a company limited by guarantees can be further classified. Here, they are classified as once when there is a share capital, B when there is no share capital. So in these two category, you can classify your company by guarantee. And lastly, there is unlimited company. So now the concept come to us. Okay, in the further two category, there was a term that was significant, was limited. So the liabilities were limited as per how much is your share or how much you're guaranteeing by virtue of a share capital, or by no capital is involved even then. However, in this category, there is unlimited term that's been used. So obviously this may have different connotations. So here again, further classification that can be looked into will be that a company that's been constituted which has liability of the where the liability of the members is unlimited, that is a unlimited company. However, in previous two category, what did we learn? That there were the liability were limited as per the involvement. However, in this case, in this scenario, the liability may fall upon unlimitedly because the liability lies also on the members of the company. Okay, so this classification you can dwell into section 12 subclause 2C. It is the type of company if the company is unable to pay the debt, the members will have to pay the debts out of their private resources because it's an unlimited liability. Yet again, I would like to assert on this aspect that members also hold liability in this particular classification. So now that we've understood, okay, a company is constituted, we've known its evolution, we've seen how you can actually get it registered or how you can classify its registration process. Now it becomes important to understand what are the salient feature or characteristics of a company. So see, a corporate body is creation of law. That's something that we've established or we've understood in the starting of our session, that it's a legal entity because it can be registered under the purview. It can be registered as per the Companies Act, under the Companies Act, and liabilities would lie as per what the law states. So this gives company certain rights, obligation, and duties as well, because it is as functioning as per the written norms. So it also, by virtue of it also has certain rights and obligation. So because of which it possesses certain level of power that is conferred upon him by memorandum of association. So when people come up together and they actually constitute a company, there is a memorandum of association that's been signed. So this is again a very detailed concept for which we can have a session later. Right now we will focus upon different salient features that are more relevant right now in our introductory session. So within the powers that are conferred, there are also certain limitation that it has, because obviously it cannot be given unlimited powers. There are also certain restrictions. However, whatever those powers and restrictions are, we will now read more about it. So once a company is constituted or formed, it gets a corporate personality because it's registered under the act. So it is considered as a person similarly as any other individual, like, because it gets an artificial person status. So that is why it is considered as a person which holds a legal standing and who can enter into contract or may possess property in their own name and thereafter also sue people. You may have read a few cases wherein, let's say, Leonard versus PepsiCo, or wherein the entity itself is involved and is suing on its own behalf. So here in this case, it becomes an artificial person, right? So however, it is called as artificial person, and as it is intangible and exists only in the eye of law. So it holds corporate personality and is an artificial person, which has a certain legal backing, which makes it a legal entity. Now, second important feature of a company is that it has limited liabilities. However, yet again, the liability may differ as per the constitution or incorporation of the company that we've read or discussed just some time before. So, yes, we know that company can buy things in its own name. However, it also becomes a separate personality when a debts are to be paid. So a liability of a member becomes limited once a company, as we discussed, it's a limited liability company, then the liability would not form or would fall upon as per the terms or the share or the guarantee. And if it is an unlimited company, then the members may also get involved. However, in most of the cases, it's seen that limited liability companies are constituted. Now, let's another significant feature of a company is that it gains a perpetual succession. Now, a thought that comes to your mind is, what is perpetual succession? So, perpetual succession is a continuation of cooperation. A company may live even if its significant members may live or die. A company would continue growing irrespective of bankruptcy, deaths, insanity, change of members. It will keep growing. So its incorporation never dies until it is wound up legally, because it has a legal status, because it's backed by the law. It would have existence until the law itself doesn't winds it up. And then yet again, it's administered as per the memorandum of association. So once you've constituted a company, thereafter the memorandum of association would come into the play. Next is, it has a separate property. A company, as we've already been discussing so far, is a legal person. So it is very different from its member. It can have property in its own name, just like any other real person. And similarly, it will have the control and ownership. Everything would lie upon them. Then is transfer of shares. As it has individual standing, it can also transfer shares, and the capital of company thereafter can be divided into shares, and these shares can be movable, which means that it can transfer from one person to another, and no shareholder can hold them permanently until there is a certain agreement within the team. I mean, that's yet again dependent on what the terms are of the constitution. Now, another significant feature is common seal. As soon as a company is consolidated and becomes a legal entity, which also has perpetual succession, it has a common seal. Because it has no physical existence, it must act through all its agent, and all the contracts that are entered into by its agent must be under a certain seal that a company gains once it's constituted. So this seal mainly becomes the official signature of the company. So whenever you see Pepsi or you see Coca-Cola signing, so they have their official signature that goes forward. So then it becomes a common seal, that is the official signature of a company itself, which it gains as soon as it's constituted. Okay. Yet again, another crucial feature is it has a capacity to sue or to be sued, because it has a separate standing. If there is a shortcoming on its behalf, any other aggrieved party may sue it, or they may sue in case they've been aggrieved by a certain conduct. and they can initiate a legal proceeding whenever they feel like that a loss has been incurred upon company by virtue of certain acts or a conduct. That's another feature. Another significant feature is that it has contractual rights. A company which is legal entity, it's very different from its own members. It can have contractual rights as well. It can enforce a contract that can be made through that a company itself is trying to establish. So those contractual rights would also fall upon a company. Then is limitation of action. A company cannot go beyond whatever the power is stated in the memorandum of association. It becomes very relevant. So memorandum of association is what that actually regulates the powers and fixes the objects of a company and provides the edifice of the entire structure. So all across you see that after it's constituted, like you can say that it's the grand norm of a company. It's the constitution, just that we have a constitution of India which actually tells how the system may function. Similarly, memorandum of association, it actually regulates what powers or liabilities a company may have. It actually provides a certain structure upon which it actually stands. So thereafter, every process that prevails, it prevails as per the memorandum of association. Now, another significant feature of a company is that it has separate management. So the member may be in a position to derive profits without being burdened as being part of the management, but they do not have that level of control over its working, or they can elect their own representatives as to conduct their corporate functioning. So as part or as a member of the company, what they will do is that an effective in order to ensure that an effective control is existent, they would have managerial body or personals who would hold significant positions, and they will make the proper decision for a company from a very comprehensive outlook. So it has a separate management as well. And that another association that comes into play during the formation of a company is that it functions for profit. That's given also because once it's constituted, there is an objective that is carried forward. So it's considered as a voluntary association for making profit. You've come together, you want to make up some profit, and thereafter you form a company as per the norms that are laid. You decide upon the type of company that you want to constitute, the liabilities you want to fall upon you. So in that format you proceed forward, and the higher objective is that there is profit. So thereafter, another significant feature is termination of existence. That is, a company, once being an artificial person, it cannot die a natural death. As we've discussed, when we were talking about the concept of perpetual succession. So it actually is similar to that concept only, that it cannot terminate as on its own until it's wound up by the virtue of law. Now, this brings me to the half discussion of our topic today. And so far we've understood, okay, there is a company. What is the meaning and relevance of company? How can it be, or how is it defined under our current law? How the law evolved over the year, and what is the relevance of the company, and what are the salient features that it may hold. During the course, we've also tried to dwell into what is memorandum of association. Now, I would like to know from all of you if anyone has any question or queries so far with regard to the concept, and if any two of you can talk about two salient features, it would be great. We can have a more engaging session then. Anybody who can talk about? Anyone who would like to volunteer? We have 44 of us. Anyone who's listened so far? You can kindly unmute yourself and just raise of hands. Anyone?
It is a separate legal entity.
Okay, very good.
It
Can you
is
please, tell your name first and thereafter give the...
okay. Myself, Pooja.
Mhm.
Yeah.
Hi, Pooja.
Hi.
What did you say? You can just repeat that again.
Okay. So, company is a separate legal entity.
Very good.
It is a perpetual succession.
It has perpetual succession.
It,
Very
yes.
good. Yes, very good. Anybody else who would like to share?
Hello, ma'am.
Okay. Hello. Please tell your name first.
I am Parvez Islam. I am from
Hello.
West Bengal.
Hello. Can you please tell me two salient features of a company?
Yes, ma'am. A company can sue any person, and anyone
Very
can
good.
sue against a company.
Very
Also,
good.
a company can hold property,
Very
and
good.
a company also a common seal which can be used for any type of official work or another work. Actually,
Yes. Thank you.
thank you.
So both of them are absolutely right. These are the four salient features that a company hold once it's constituted, and it within the purview of Section 2, subclause 2 of the Act. Thereafter, there are certain features that it gains once it's constituted. So that is very important and relevant for us to understand. Now, this moves us to the next part of our discussion that is very important for all of us to understand. That since the start, we've been talking about, okay, it has legal entity, okay, it gets legal status. But it's very important to understand the nuances of how relevant it is to have a separate legal entity for a company. Why is it getting this status, and what is the doctrine or a concept behind this legal entity? Okay, because it's constituted under the eye of law, but why is it given a status of artificial person? Okay, and what all benefit it may incur once it's constituted as a legal entity? So all of this is actually derived from a concept of a doctrine of separate legal entity, which is a concept that itself gives company a legal status. It makes it different from its owners. Let's say today I go and I along with a few of my friends, I constitute a company. Now I know that it has a legal status. Now I know that I will not hold as much liabilities because it has a legal status. It has a certain legal backing, and the law has defined its roles and functioning, so I become free out of it. But would that be a case always? And how is it getting those status? That also becomes very important, because I am the owner. Okay, eventually I am the owner. So because it has got that legal status, or because it has become that in artificial person, it itself got separated from me as me being an owner, because I've constituted a company. I mean, not separate, definitely there are other liabilities that I may have, and that's definitely in line with the memorandum of association. However, if we only talk about the legal status, then I would still have my own legal standing, and my company will have its own legal standing. So it's at that very moment it becomes different from me as an owner. So the company and I become two different legal entities, and they can be made separately liable for any offense. If I am I'm doing any conduct, you can make me held liable for the offense itself. And also, if certain conduct is undertaken by me via my company, also then my company can be charged for it. Okay, so what is the doctrine trying to tell us? It is trying to tell us that a company will have its own significant obligations, it will have its own legal rights, it will have its own existence, which will be entirely different from me as the owner of the entity. So that is what separate legal entity doctrine talks about. The doctrine says that for the company to be called as a separate legal company, it is important that there has to be proper incorporation and registration of the company. So you have to follow as per the certain types that we've discussed. It's important that all those and also the processes that are mentioned within the act, all of those are taken seriously, and the incorporation is followed as per the laid format. It is only then it gets a legal entity status. So it becomes relevant that if a company is incorporated as per the laid laws or the ground, it then receives a separate legal entity status. Now, in those incorporation standards, there are certain standards that may include that are there has to be director of a company. Okay, you've constituted a company. Now there has to be somebody who's working to regulate the functioning of a company. Okay, so that person who's regulating the processes is the director. And then there are also specification of what number and count of directors can be for a company. Second thing that becomes relevant is that there should be more members to the company. There should be real owners of the company. So just like a company has a legal entity, and we've learned that, okay, it has a characteristics to transfer share, buy property. So let's say a company is buying company only. Okay, so that can be a case, but that's again a very few when not at the constitutional level. Once you're constituting a company, it's important that it has certain people who are regulating it as directors. There are certain real owners who actually are member of the company. So all of this becomes relevant in order for it to get a separate legal entity status. And then yet again, there has to be shareholders. These shareholders should subscribe to certain share. The company is constituted of certain share, and then there has to be certain shareholders that have certain holdings. So we've learned that once a company is incorporated, there were also liabilities that were divided as per the shares. So then it in the start only, when a company is incorporated, there has to be defined responsibility of who's getting what share and what is the level of liability that may be fall upon them, and then who are also its member, who are also director. Once you follow all these steps that are in detail laid in our act, you will be able to constitute a company which has a separate legal entity status. Now, we've learned about all this and we've learned about the doctrine. Now it is very pertinent for us to understand how did the concept evolve, and why are we since 40 minutes talking about separate legal entity. And it's so easy to understand, because as a layman, it gives a very simple connotation. Okay, legal entity, okay, get a legal status, you are a legal person. However, the concept is so detailed that you need to understand that what are the nuances that are very pertinent in order for it to get that status. So once we've talked about the doctrine and its relevance, now we also need to dwell into how the concept evolved. So this concept for the first time was applied in a case which famously is called Solomon versus Solomon. So if I have to give you some background and facts about this case. So what happened in this case, Mr. Solomon, he registered a company under the Companies act as per the laid norms. And when he was constituting a company, he actually took along his own family members to be the shareholders of the company. Okay, like the concept that we were talking about, that shareholders are important, and then there has to be certain division of shares is also very relevant, that who holds what level of shares. Any people can have equal shares as well, they can have 25% or four people have the similar share. Okay, they're all shareholders of the company and their share is 25. So similarly, when Mr. Solomon was registering his company, he made his own family members part of the company as a shareholder. And thereafter, in the year 2007, company had subscribed to certain share. And Mr. Solomon, what he did was he circumscribed to a certain sum, and his family thereafter circumscribed to certain level of fund. And the value of each share became €1. Okay, that was the share of the each value, and thereafter he subscribed to certain sum, the company subscribed to certain sum, and the other shareholders. So this was the division. Mr. Solomon came forward, registered a company, took his own company as the shareholders. There was a division of share wherein the company had certain share. Then his shareholder also had some, and then he himself also had a certain share, wherein the larger number was with Mr. Solomon himself. And he became the managing director of the company. Thereafter, what happened? Some financial difficulties were in play, and because of which the company had to go through the liquidation process. And once the company was going through the litigation process, there was a particular rule that was there with regard to, or there was a certain law, as a liquidation law that applied on this company, was that as soon as the company would go into liquidation, the first person who will be paid will be the secured creditors. So the creditors would be paid first, and thereafter the unsecured ones will be given their own percentage or their own shares. Now, when the distribution started, Solomon was himself a secured creditor, so he also wanted his own share. And once the sum was given to him, the unsecured creditor won't get their own sum. So then, in this case, the case was brought forward, and then a decision was given that even though Mr. Solomon held the major share in the company, even though he was the managing director of the company, but as he was himself a individual and the company having its own separate legal entity, the laws or the doctrine would come into play, and Solomon would get the share in the company, because there are two different personalities that are involved. One of Mr. Solomon, one of the company itself, and the company being Solomon and Company. Even though him being the owner, but yet because he was he was just one of the shareholder of the company, and also fell into the category of secured creditor. So he would be considered he is already, because of the constitution, he is already separate from the company that's been constituted. B, he would also be getting his share because he falls in the category of secured creditor, which are the laws that were laid. So this is one very significant doctrine within the company law. In order for you to understand the nitty-gritties, it's very important for you to understand not just that it is a legal entity, but you have to also understand why it is a legal entity. How did it get the legal entity status? Now, we've heard about unlimited company as well, one of the categorization of the company. And most of the time, you cannot let go of people if there are malified intentions of involved, or a certain conducts that have been undertaken in order to actually reprimand the company, or in order to take advantage of its separate legal status. So it becomes important that you understand that in spite it has a legal status, but there are certain exceptions, and in those exceptions are such that because of which that even though it has a legal entity, their members can also be held liable, and that concept is lifting up of a corporate veil. It is a one significant exception of this separate legal entity concept, and it actually states that you cannot blindly trust its member, even though in the Solomon case it was by the virtue of the facts, it was proved that there were no malified intentions involved. However, in cases where malified intention are actually involved, in those scenarios, what we do is that we lift the corporate veil. And here the veil is, if I simplify the term, it means parda. So you actually lift the veil, and you see who is standing behind the company, who are the people who are actually the regulators of the functioning of a company. And then those people would be taken into account, or they will be accounted for the actions that are undertaken, because we cannot trust blindly that members were innocent and there was no malified conduct involved, or there was no intention to fraud, or in order to gauge benefit by virtue of the company. So once a certain conduct is in play, then there are when the procedure or investigation is undertaken, then we look into that how the functioning of those members impacted the impact that the company is facing. So let's say today, I being the member or the owner of the company, I intentionally go and invest a certain number of share, and I know that my company doesn't has that level of financial standing. So in those scenarios, I'm well aware that what liabilities I'm making my company go through, or what liabilities would fall upon my company, and even after that, I'm undertaking such a conduct. So when this issue is raised, there could be the lifting of corporate veil, and the person who's actually undertaking the relevant conduct can be held liable. So basically, this concept is this only, that whenever there is a circumstance, or whenever it's observed that there are arbitrary conduct or a willful conduct undertaken, in those scenarios, lifting up of a corporate veil is undertaken. It is, if I simplify it, then it refers to a situation wherein a shareholder himself is held liable for whatever debts that fall upon the company, despite whatever rules of its incorporation are. We've learned at the start that there are certain liability as per which a company is incorporated or constituted. So despite those laid norms, a shareholder can be held liable. And this veil doctrine comes in play, and then what it does, it blurs the legal liability status that were given separately to the individual and company. In these scenario, the corporation and the shareholder, both of them can be considered as equal, and or same, and then they will be held accountable for the actions that are undertaken by the company. So there are mainly two main ways through which a company can become a liable. Either it can have a direct liability. B, it can have a secondary liability. We've learned about the direct liability. If there is some direct infringement that are undertaken by the company itself, it becomes liable. Secondly, if there are secondary liabilities. Now, what is a secondary liability? We've just talked about the concept of corporate veil. There are individuals who are acting through the virtue of their employment. Those human agent, their act would be liable, and that liability would be considered as secondary liability of a company. So with these two doctrines and the concept, we've come to the end of our session today on introduction to corporate law, introduction to company law. For further discussion, we can have sessions on memorandum of associations or the further processes that are more relevant when a company is constituted. And yeah, now we are open for questions. I'll just go through the chat first, because I could see some through lifting up of a corporate veil, only managerial position would be liable, or how can shareholder? Okay, so thank you for the question, Mr. Ibrahim. Once a veil is lifted, there is a sequence that comes into play, that who will hold a certain level of liability. There is not a specification as to what managerial position would be liable for, because that again vary from facts to facts. If a certain conduct has been undertaken, we are not talking about liquidation, that liquidation process. We are talking about the liabilities here. So it definitely would be dependent on the facts that are in play, and thereafter the case would flow. Anybody? Okay, I'll just see if there were more questions. How to start a career in a corporate firm? Okay, so it depends where exactly you want to practice. If you want to go into law, if you want to go into law firm practice, then you'll have to apply at certain law firms and you can get started. Then other than that, if you want to join into other, other firms who are not core law, but they may have legal compliance division, so you can apply there as well. So that may help you in starting a career in corporate firms. Dia, can you tell me which is the best field in corporate company and how to start in my? I think the previous question would have answered your query. Recent amendments scrapped the requirement of common seal. I am, so basically common seal is the status that you get once a company is constituted. So I mean, requirement becomes secondary. We are talking about the constitution here. So yes, only those who know the definition of corporate will, okay, how to convert, okay. Are you going to tell everything about corporate law which is used in practice? Okay, when you say in practice, I mean that also depends upon what is that you have in your mind. If this is about introduction to corporate law, it is very important for us to understand that what actually impacts the corporate law, the company itself. It is a company law. It is the law for the company. So it's very important to understand those nuances first. And then, yes, I'm happy to hear if you tell me, are you going to tell everything about corporate which is used? Okay, you can maybe tell me what is in your mind. I mean, going to everything about corporate law, by everything, if you could give me a little backdrop there. Okay, Rosie Praveen, I am a student of BL, want to enter corporate field, but it seemed difficult for me. I have a lack of proper guidance in my university and even semester covered communal. I didn't understand as well. How should I prepare for myself? See, I mean, considering that we see, I want to practice, I see a lot of people having this query. See, what is important is you need to know the law first. You need to know the nitty-gritties of the law first. Okay. So first you have to be ready to be a student, not just, it shouldn't be that I want to enter the field, so I should, or, how can I enter? It is important that you prepare yourself first. Once choose your field. Corporate and commercial law has a wider ambit. Okay, if you only talk about corporate law, then you need to know the law first, and thereafter the avenues that you can explore, and that yet again become that you want to which if you want to join a law firm, if you want to join a company, or you want to be a researcher. So all of those is dependent upon your interest, and that will only develop when you read the law, when you understand the nitty-gritties of the law. Corporate, we can't get access. Please suggest how can we go through such process after you're done with your law. It depends yet again which area you want to go in. Just if I'm being very honest, after 5 years, it is significant that you, or 5 year or 3 year, you may, all while that you are having your coursework, you can make up your mind what particular domain that you want to go into. You want to go into securities law, which is securities law, one of the significant part or aspect of corporate affairs, or corporate laws. So you have to see that wherein your interest lies. It's very important. If you only feel like, okay, want to go into certain firms or things like that, I think it's important for you to know where you want to go, because even if you land up in a job, you may not be able to sustain. So it's important for you to read more, so you learn about your own interest. So that's that. I want to how to start, ma'am. Can you suggest some firms and companies for internship? Indirectly, you will be liable. Indirectly, director of a company will be liable for any crime. I mean, crime is a criminal liability if there is a certain act that's indirectly director of a company will be liable for any crime. That vary from facts to facts, that whether what crime, I mean, that's also dependent upon what crime. And directly, indirectly, the concept of lifting up of corporate veil is that only that you've lifted up the corporate veil. Now you've seen that, so this is a secondary liability that falls upon. So that's the flow. And yeah, I think that's about it. If anyone has any more queries, you may reach out to me over LinkedIn or over email. Akshay can share the email address. And if we have no more queries, how can a company itself be punished? Sir, company can, once a conduct is undertaken, a company as a legal and separate legal entity can be held liable by somebody who's charging it, somebody who's in aggrieved. So if we have no more questions, okay, result will be due to conduct of management. See here again, sir, if the management is has underplayed, or there are malified intentions that are involved, then in those contexts, lifting up of what corporate veil would come into play, and then they can be held liable, like we were talking about the doctrine and how it's the secondary liability on a company. What will happen if a company has unlimited liability? Is called unlimited liability. Definitely, I mean, once a constitution of a company with unlimited liabilities would mean that its members are liable. That is the meaning. Company's liability will be defined otherwise if during the incorporation itself. Company law related internship, please tell me. Company law related, I mean, there are a lot of firms that directly deal into company law. So you can just dwell into that, what all firms have specific, practice, and then you can just drop in internship. Okay. Is in unlimited liability company, you said shareholders will also have liability. Yes, sir. So the category of unlimited liability is this, that its meaning itself is that members will have liability. And once a company which is constituted as per limitation of liability by shares or by guarantee, in those scenarios, the member will be free by any liability. Only in the scenario of unlimited liabilities, this can be the scenario. This is one case wherein the liabilities fall upon. Second is once the lifting is done. Once the lifting of the corporate veil is done, then the liabilities would fall upon. Are not members and shareholders will be different. Definitely, sir. They are different. Members are different, and shareholders are different. Shareholders have a definite, shares which define their liabilities. How can we differentiate between company and civil wrong and crime? It's very easy, as company civil wrong and it depends on what act is undertaken. If it involves injuring an individual physically, or it becomes a crime. And if there are certain conduct that have impacted a person or public at large, then it's a civil liability. So it's for companies liability, then there is a clear basic differentiation of the act that's undertaken, the nature of the act. So in those scenarios, obviously a company cannot murder somebody. So if criminal liability of that notion are in play, then the company would not have the liability. Obviously, the case would also not be under those parameters. So yeah. And then, ma'am, why liability shall go to shareholders? Why not confined to management and members? Sir, see, in order to understand the segregation, it is very important that we decipher it from case to case basis. Whatever the memorandum of association would detail upon, as per those detailment, the liability will fall. So right now we have only discussed about the constitution of a company. We're not talking about the liquidation process. Once if you read in detail about the liquidation process.
Thank you, ma'am,
Yeah, okay.
and sharing your knowledge with us of the corporate world. And thank you to the wonderful audience for your active participation. Stay connected with Legal Innovation for
अरे
more
वैभवी
insightful
वैभवी
webinars like
वैभवी
this.
वैभवी उन्हें 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 आंसर कंटिन्यू करने दे.
Your
Okay.
voice is lacking.
Okay, so to wind up my discussion, I just wanted to say that the liabilities that you're talking about, those liability will fall once a conduct is in play. And those liabilities are defined by the memorandum of association itself. Okay, once whatever the memorandum of association would define, as per those standards, the liability will fall. If the constitution is such that a company itself is an unlimited company, then in those scenarios people can be okay. Ma'am Rosie said you are doing internship for freshers. I am okay, if anyone is interested, I have this. Okay, so I'll just finish that, and then I'm sorry, the focus just broke. So Mr. Ibrahim, I would tell you that this is as per the constitution. It would start going into the nitty-gritties of the case. That would vary as per the case, that who would have higher liability. However, once we talk about unlimited company, in those scenarios, it's very, 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 very clear that its members will have liability, because they are the one who have come forward to constitute a company. Shareholders are part of a company, but they have a definite shares. So once a case comes into play, if that again varies from case to case. For unlimited is just that there will be liability on its member. For unlimited, for limited company, there will be liability as per the segregations that is there. Then it becomes that, okay, if shareholders, if a company is constituted by shares, then shareholders will hold a liability. Once it is constituted as per the guarantee, I think the confusion lies here. Shareholders will be held liable once the constitution is by share. Guarantees, when the constitution is as per the guarantee, then the guarantors will be held liable. For unlimited, the members will be held liable. And if you talk about during the later stage, when the liabilities are actually in play to be fell upon, then the facts of the case should be welled into that what is the conduct. Okay, so I hope that answered it. A company has no hand to work. People who compose the company actually will be held liable. Yes, but it does has a separate legal status. and because of which only in certain scenario it will be considered to be functioning through its members, because no conduct is undertaken by a single person here, and there are higher objectives that are involved in a particular conduct. That's also there. Okay, now talking about Dia, your query. If yes, I as a vice president of India-Italy Business Council, we do have some internship openings. If anyone who's interested and genuinely has time can connect, and the requirements are that you should be good at social media. So yeah, that's about it. I think we've overshooted our time, and I hope everyone's query is clear. If not, please feel free to reach out any given time. And yeah.
Okay, everyone is
you-
over.
Okay.
Thank
Do
you,
we
ma'am,
have?
for this enlightening session.
My pleasure.
Thank you to the wonderful audience for your active participation, and stay connected with Legal Innovation for more insightful webinars like this.
Thank you.
Thank you, ma'am.
Thank you, ma'am. Thank you, Vaibhavi.
Thank you, everyone. Have a good evening.